Good evening, folks. My name is Mustafa Indanusa. If you are a landlord or if you are a tenant, then this video is for you. It's going to talk about the latest in landlord-tenant law. So on December 28th, 2020, a new law went into effect. It's the Emergency Eviction and Foreclosure Protection Act that went into effect, and that's what I'm going to be talking to you about today. But before I get into that topic, I just want to talk about something else that's sort of impacts what has been happening in landlord-tenant litigation over the past several months, almost a year now, since COVID. My name is Mustafa Indanusa. I've been practicing landlord-tenant law since about 2001. I work at Davis, Indanusa, Ikhlas, and Salim. We are a general litigation firm. We do landlord-tenant work. We do all sorts of litigation, personal injury, and those type of litigation cases. But today, as I mentioned, I'm going to be talking to you about the latest act. It's the Emergency Eviction and Foreclosure Protection Act. But as I mentioned in the beginning, one of the things that I think is important for landlords and for tenants is what resources are available for you in light of what has been happening and what I'm going to be talking about later in this video. Well, one of those resources is the RRP, which is a rent relief program. And that's a program that has started back, I believe, in July of 2020, but it was reactivated recently. And that program is going to be open until February 1st of 2021. And you can find more information about that program by going to hcr.ny.gov/RRP. If you qualify for this program, what would happen is you would get some money. It's not like the one-shot deal, but you get some money that will be paid directly to your landlord. It wouldn't be paid to the tenant, but it would be paid directly to the landlord. If you already applied for RRP, then what you will be getting is an email telling you about the next steps. So if you are a tenant, you should definitely apply for it and see whether or not you qualify. Go to the website. Again, that's hcr.ny.gov/RRP. If you are a landlord, tell your tenants about it so your tenants can apply. The second resource is something that's always been available even before the advent of COVID-19, and that is the one-shot deal. You can call 311. You can go to the HRA website, but I suggest you call 311 and just ask someone to direct you on where you can get information about the one-shot deal. Before COVID, you had to wait until you were in court before you could get a one-shot deal, but my understanding is now you don't even have to wait to go to court, but you pretty much have to go through the same process, and it could be a loan or it could be a grant. But definitely that is a resource that's open for tenants to be able to pay landlords, and in the times that we are living in right now, this is a very important resource to take advantage of. So now let's talk about this new law, the Emergency Eviction Foreclosure Protection Act that went into effect December 28th of 2020. So there are many different provisions that's going to impact landlord-tenant litigation. So if you're a landlord and you're a tenant, this is something that's going to impact your life, especially if you're a small landlord. So one of the first things we want to talk about is commercial cases. Commercial cases are sort of a little bit of a separate part, but with commercial cases, if you are a commercial tenant and you are, I guess, maybe behind in your rent, and you are the landlord that has commercial tenants, you cannot commence a commercial case, a non-payment case against a tenant until at the earliest after January 31st of 2021. We don't know whether or not that's going to be extended, but we'll see. Today's date, by the way, is January 8th, 2021, and the reason why that's important, and in all of my videos I try to mention the date, is because things change so swiftly that if you're watching this video later on and you're not, you may want to just check on what the latest status is for many of the things I may be talking about right now, because things have changed very quickly. So now moving over to residential. First we covered commercial, but what about residential? For every residential case that was commenced on or before March 7th of 2020, all of those cases have come to a halt. There's a stay on every single case that was commenced during that time period. If now, on the other hand, a case is commenced between December 28th and I believe it's February 27th of 2021, then those cases will be stayed for 60 days. So I want to repeat that. If you have a case, you're in landlord-tenant court right now, whether you're waiting for trial, whether you're waiting for some other step in litigation, those cases are going to be stayed until about through February 21st. It's for 60 days. If you don't have a case that's already been commenced, but your landlord then commences a case between December 28th and February 27th, then those cases are going to be stayed for an additional 60 days, pretty much from whenever that case is commenced. Now, the moratorium on eviction is through March of 2021. So that's just normally if you have any kind of case and you're facing eviction, generally for everyone, the moratorium, the stay on all evictions is through March of this year. However, if you file a hardship declaration, and you actually not file, but if you serve your landlord or homeowner with a hardship declaration, then your case is going to be stayed for an additional 60 days. Now, the hardship declaration, you can find that online. It's in the New York State Court System. So you should just go to Google hardship declaration. You'll see a form. The form will have like two places where you can check, depending on whether or not your hardship is financial or some other type of hardship. Once you check one of those areas, you want to mail a copy, mail the original to the landlord. You want to keep a copy for yourself. What I suggest for people to do is to mail it certified mail, so you have a record of it, because that's going to be important as to when you actually mailed the hardship letter or the declaration to the landlord. Once the landlord receives this hardship and you are in litigation, or even if there's litigation that's going to be commenced, that's going to give you an extended time period through May of 2021 before a case can be commenced against you. So it's very important that if you are in this situation, then you file the hardship declaration. The hardship declaration, if you are a landlord, this is something that you have an attorney. So just for something like this, you probably want to speak to an attorney, because there's so many different steps now with this, with the passage of this new law. If you are a landlord and you are sending a 5-day notice, this is the 5-day notice that has been required since June 15th of 2019. Before, you didn't have to give this 5-day notice, before June of 2019. This is the 5-day notice that you send to the tenant, telling the tenant or advising the tenant that tenant is late with rent. You have to send this hardship declaration, a copy of it, with the tenant, to the tenant, in the tenant's language. Right now, they have English and Spanish on the website. They're trying to get other languages available. If you then have to send a rent demand, which is after the 5-day notice, you also should send the hardship declaration. If then you have to commence a case against a tenant, you should also attach a hardship declaration. If that's not attached, that could mean that your case is defective and your case could be dismissed and you have to start all over again. Now, defaults. In one of the videos that I did before, I think I advised people that defaults would be taken. Again, that's why the dates that I give in the beginning of the videos are so important, because the law changes. So if you were listening to an old video where I said the defaults were being taken, defaults are no longer taken anymore, at least not for the time being. There are not going to be any defaults that are going to be taken, or if there is going to be a default that's going to be taken against a tenant, then the court has to have a hearing before they can grant a judgment on default and then move forward with a case based on a default judgment. But and this is not going to happen prior to May 1st. If your case was defaulted, they won't be getting the default judgments prior to May 1st. Now, what about warrants? The warrant is what the marshal is going to get in order to move forward with an eviction. So if a warrant has been issued prior to the passing of this law, or prior to even March 7th of 2020, if a warrant has been issued but has not been executed, that's also being stayed until the court has a conference on whether or not the case should move forward and whether or not the warrant should be executed and given to the landlord, and then the marshal can move forward. But of course, the marshal can't do anything until the moratorium on eviction has been lifted.